Hello viewers and subscribers, Assalamu alaikum. This is Tajul Islam from Aini Pathshala, and as per our regular class and discussion on several legal topics, today I will discuss about child protection in Bangladesh, a legal framework. And we know Children's Act 2013 is now operating in Bangladesh, and according to Convention on the Rights of the Civil, CRC is said to universal in this regard. Universal Convention, CRC is said to an universal convention as almost every country of the world signed the convention except USA, and Children Act 2013 is such an act in Bangladesh where the main and only subject matter of the act is child. Both in CRC and the Children Act said all the human being under the age of 18 years are considered as child. UNICEF uses the term child protection to refer to preventing and responding to violence, exploitation and abuse against children, including commercial, sexual exploitation, trafficking, child labor and harmful traditional practices like child marriage. These are the exploitation format of children in our country. Underpinning the UNCRC are the four mutually reinforcing general principles identified by the Committee on the Rights of the Child. These principles provide a framework for the interpretation and implementation of all of the rights contained within the UNCRC and should be reflected in all relevant policy and practices. These are non-discrimination, the best interest of the child, that means maximum welfare of the child, the right to life, survival and development, the right to be heard. And now take a look to Bangladesh laws, how laws have worked in favor of child protection and follow the core principle of Child Rights Convention. Constitutions of the People's Republic of Bangladesh, Article 18, Sub-Article 2 of Supreme Law of the State, stated that all forms of prostitution shall be prevented, included child prostitutions. Article 35, Sub-Article 5 says that no person shall be subjected to torture or to cruel, inhuman or degradation, punishment or treatment. Hereby the word no person included every person as well as child, and especially mentioning about corporal punishment which should be prohibited. The Children Act 2013, as per section 7, 8, 9 of this act, for the welfare of the children, there shall be established a board in national, district and upazila level where duties of the board centers or certified institutions and where the duties of the board are to supervise, monitoring, evaluate and the activities of the child development centers or child certified institutions. And sections 63 subsection 1 mention that the government shall issue office order directives to determine the minimum standard of proper care which shall maintain by the children welfare center and certified institutions. According to section 54 subsection 3a, children's court may pass order to ensure the protection and confidentiality of the child and information of the child involved in the judicial proceedings, and not to make public by who is the concerned child may be identified. Section 70 of the Children Act 2013 says about the penalty for cruelty to a child. Any kind of assault and corporal punishment which is represent cruelty to a child is called offence. If any person commits such offence, may punish with imprisonment for a term which may extend to 5 years or with fine which may extend to 1 lakh or with both. Chapter 9 of this Children Act 2013 penalizes some act which is contradictory to child protection and rights, such as penalty for child beginning, child exploitation, allowing child in brothel, encouraging child to seduction, etc. Domestic Violence Prevention and Protection Act 2010. Section 3 of this act defined the term domestic violence, where violence against child and also included in domestic violence. It says that domestic violence means physical abuse, psychological abuse, sexual abuse or economic abuse against a woman or a child of a family by any other person of that family with whom victims is or has been in family relationship. As per Section 7, service provider who are registered under any act or any registered NGO shall be protecting the human rights, especially the rights and interest of women and children by any lawful means, including providing any legal aid, medical, financial or other assistance. The Prevention and Suppression of Human Trafficking 2012 Section 3 subsection 2 protected children by confirming that in Section 3.1 define that trafficking by means of threat or use of force, deception or abuse of social, economic or environmental or other types of vulnerability and giving, receiving money. But in terms of children, if trafficking happened, it shall be immaterial whether any of the means of committing the offence mentioned in Section 3 Clause A to C of subsection 1. According to Section 32, the process of identification, rescue, repatriation and rehabilitation of the affected person shall be conducted with the special regard being paid to the welfare and special needs of women and children, and in a victim-friendly manner. And every human trafficking victims, including children, shall be entitled to give consent to get medical treatment and legal aid as well as psychological counseling as per the Section 36(2). The Prevention of Oppression Against Women and Children Act 2000. All kinds of child sexual abuse are penalized, including contact and non-contact sexual act and all penetrative and non-penetrative sexual acts. And the law provide equal protection to boys and girls. Section 9 of this act not only mention girls, the provisions also mentions about boys too. Equality or non-discrimination. Muhammad Abdul Salam versus State Rule number 23508 of 2013 interpreted Section 9 of Preventive Sexual Acts against Boys. If anyone committed rape for this consequence death, then she shall have punished with rigorous imprisonment for life and with fine. As per Section 10, for sexual operation with women and children shall punished with imprisonment for not extend to 10 years, less than 2 years of rigorous imprisonment and also fine therewith. According to Section 31, there is a system of safe custody. The Penal Code, according to Section 37, abandonment of child under 12 years by parent or person having care of it considered as an offence. Section 364 says about kidnapping or abducting a person under age of 10. So whoever committed such violation shall be punished for a term which may extend to 14 years and not less than 7 years. As per 366, whoever by any means whatsoever induces any minor girl under the age of 18 years procuring, seduce to licit intercourse with another person shall be punishable with imprisonment which may extend to 10 years and shall also be liable to fine. Section 375 mention about rape, and it will be considered as rape if any person knowingly seduce other with or without consent under the age of 14 years. And Section 376 says about punishment of such offence. The Guardian and Wards Act 1918, this act given power to court to make order as to guardianship in Section 7. If the court satisfied for the welfare of a minor, then may give the order appointing a guardian. Section 17(3) says in appointing guardian of a minor, the court considered the minor preference if he or she is old enough to form an intelligent. The Pornography Control Act 2012, the Child Marriage Restraint Act 2017, Section 7 of the Act, it says that if any person committed child marriage, then it shall be an offence. Subsection 1 says that if any major gets married to a minor, then he or she shall have punished with the term not exceeding 2 years or not less than 1 lakh taka or both. According to section 8, if any parents are involving in doing child marriage, then it will also have considered as an offence under this provision. In section 19 of this Child Marriage Restraint Act 2017 says that for the welfare of the child, if the guardian wants to getting their child married with the consent of the court, then the particular situation in marriage, the child marriage shall be valid. Bangladesh Labour Act 2006. According to this act, the minimum age of working is 14 years, and there is a full up chapter about employment of adolescent workers, chapter 3, as per section 34, section 39, section 42, prohibited the work of adolescents which are in underground and underwater, as per section 284, and all the above mentioned legal provisions are reflected of those four fundamental principles of the Convention on the Rights of the Child, by which are setting a standard of child life and are protecting them from violence, exploitation, abuse. But those provisions are not enough to grow our child properly unless we are responsible to give them a protective environment in early childhood, because early environments influence the developing brain. এখানে দেওয়ান আলী কবি, স্টুডেন্টস অফ ডিপার্টমেন্ট অফ ল হিউম্যান রাইটস, ইউনিভার্সিটি অফ এশিয়া বন্ধুরা আশা করি this sort of video will be very much immensely benefited for the legal concerned students, lawyers and judges. So you will get regular notification from this Aini Pathshala channel. Then you have to subscribe this channel, and please click the bell button for getting all notifications from this channel. Thank you everybody, and if this lectures is good to you, then click on like and share. Thank you everybody. Assalamu alaikum.